1, 2, test 1, 2.
Good afternoon and welcome. We are here for oral argument today on Republican National Committee et al. Versus Fontes et al. It's our number CV-25-0089. A couple things before we get started. We're in a different place. We're not in our usual courtroom. We're excited to be here at the University of Arizona College of Law. It's always a thrill for us to come down. And I think both this case and the next, both very interesting cases. So for the lawyers, obviously, you have 20 minutes each, and you may keep whatever time you wish for rebuttal, but you have to keep your time yourself. I don't know if I think the microphone is on all of the time for the justices. Please be aware that you need to hit the button and then turn it off after you're done, because I think otherwise we get that weird echo chamber effect. So with that, Mr. Bender.
Good afternoon, Madam Chief Justice. May it please the court. If the legislature provides by law that an agency shall follow a specific, comprehensive process in promulgating a certain rule, and the agency follows that process, the rule is not invalid. That is common sense, but it is also the law under ARS 41-1030A, which specifies the grounds on which a rule can be declared invalid. It says that a rule is invalid if it is not made in substantial compliance with the rulemaking sections of the APA, unless otherwise provided by law. So when the legislature otherwise provides by law a distinct, comprehensive rulemaking process and the agency follows it, the rule is not invalid.
Why doesn't that interpretation make 41-1002A, the language that talks about an express exemption, superfluous or meaningless?
Yeah, a couple points on that, Your Honor. First of all, that provision is broader than 41-1030A because it accommodates express exemptions for entire agencies, right?
Or proceedings.
Or proceedings. And so there is much more potential for conflict between the or proceedings language. But the unless otherwise provided by law clause is the more recent clause. And so to the extent there is a conflict between the or proceedings part of 1002A and 1030A, then the otherwise provided by law clause as a later statute has to prevail.
If that's, and I get that from if we interpreted the express exemption to deal just with proceedings or whole agency exceptions or exemption, but then you go to 10005 and it's very specific in terms of, some of them that for these proceedings that are governed by this other statute. From your interpretation, they didn't need to do that. Why list that when they could have simply relied on unless otherwise provided by law?
Well, I think for one thing, when the APA was enacted, or the current version of the APA was enacted, they did need to do that, right? Because the otherwise provided by law clause comes in later. It's also greater clarity, which frankly is helpful to this court and all of us when they specifically list it. But I think the problem with the respondent's interpretation of the otherwise provided by law clause is that it makes it entirely superfluous, right? And it's a cardinal rule of statutory interpretation, which this court relies upon regularly, that words aren't to be read as surplusage. And that's especially true when it's the later enacted part of the rule. And that interpretation that the secretary has offered is consistent with not only 50 years of practice by secretaries of state and governors and attorneys general of both parties, but that's also become the public meaning that the legislature has reacted to and has made part of the statutory history. Because the EPM...
No, I was just wondering, and through that, I'm wondering, is there a road to go through this through 16444B when it talks about any laws that conflict with, that are, I guess, related to election law, that conflict with this article, which this article contains the EPM requirement? Is that in and of itself sufficient to be either an exemption, at least for that proceeding, or another law under 1030A?
Yes, we believe that the combination of 16444B and the specific procedure set out in 16452 qualifies as an express exemption under 41-1002A, also qualifies under 41-1002B, which says that the APA trumps another statute that would diminish its procedures unless the other other statute expressly provides. And 1644B does that exact kind of thing. So we think that the court can reach the same result under multiple avenues. But I do think the statutory history is important, right? This 16452, the EPM statute, is not a backwater statute. The legislature has amended it repeatedly over the years. It has done so as recently as in 2019, when the legislature added the October 1 and December 31 deadlines to the statute. The legislature surely knew, as everyone in the election space knew, how the Secretary of State has promulgated the EPM, which was pursuant to the specific statutory procedure, not pursuant to the APA. And the legislature did not see fit to do anything to disagree or direct the secretary to do otherwise. And in a case like this, that is good evidence of what the legislature understood these confluence of statutes to mean. Likewise, there are at least 16 statutes in which the legislature refers to the EPM as being adopted pursuant to 16452 without mentioning the APA. We cited these in our briefs. And the legislature uses the same phrase, adopted pursuant to, when it specifies some statutes that are adopted pursuant to the APA. And so this is further statutory evidence that the legislature believes that the EPM is adopted pursuant to the 16452 process, not the APA process. And this court has indicated, although not squarely presented, its similar understanding. In the Arizona Public Integrity Alliance versus Fontes case, this court said the secretary must follow a specific procedure in promulgating election rules, and then described the 16452 procedure without mentioning the APA at all.
Yeah, but counsel, to be fair, the APA wasn't in question then. So when we were talking about it, there was in a very different context. So I don't know if that carries all the weight you want it to.
Well, and I'm not trying to suggest that that's the main basis on which this court should agree with us, but I do think it is further indicia of what everyone in the space has understood. And it relates both to our statutory interpretation argument, but also to our prospective-only application argument, right? And it relates to the idea under Turkin versus Gordon and other cases that if this court were to agree with the other side, that decision was not reasonably foreshadowed and should be applied only to EPMs promulgated after 2025. I'm happy to talk about that further if that's of interest to the court.
And just a question on that, and correct me if my factual premise is wrong. This was asserted by the other side, and I don't know what the situation actually is, but it's been over 6 months since the Court of Appeals ruled that the EPM applies. The EPM must follow the APA procedure, and they allege that the Secretary has done nothing to comply with the APA since that time. And one of the factors for prospective application is inequitability. It sure seems that if the secretary is doing nothing to comply, that factor, and all three factors have to be satisfied, apparently, that factor would be in jeopardy.
So the secretary has taken the principal step that he could have since the Court of Appeals opinion, which is to extend the public comment period to 30 days. And he allowed 30 days of public comment. And so I don't think there's any inequitable action by the secretary. I would also say that the Court of Appeals decision was not final. No mandate is issued. The secretary was well within his rights to seek further review in this court. And so I think would be careful to suggest that somehow weighs against the secretary that he sought further review in this court. But he did do the main thing that they've, I understand the other side to have complained of two things, that the secretary for the 2023.
Counsel, before you move on real quick to those other two things, other 2 points, I want to ask you with respect to taking public comment, under what authority did the secretary take public comment in developing the 2023 manual?
Well, the secretary is well within his rights to publish a document on his website and say, if anyone would like to tell me their thoughts on this.
Yeah, but as I understand the argument here, 16452 provides a separate process by which to develop the EPM. And Secretary of State only has the authority delegated by law. And if 452 doesn't provide for public comment and the APA doesn't apply here, which would require it, then under what authority did the secretary invite public comment, which kind of kicked this all off?
I think it would be within an officer's implied authority where consistent with other statutes to, if they're going to take some significant public action, to invite comment on that. And I don't think the other side has argued that it was illegal for the Secretary of State to post the EPM and
sure, but I mean,
seek
posting
comment.
it's one thing, and this kind of gets down to where we're trying to understand here. Is the EPM its own separate procedural method of promulgating rules, or does it have to be consistent with the APA? The RNC's argument, it does have to be consistent with the APA. So the initial 15 days wasn't enough, and all these other procedural rights and duties then follow. And the Secretary's argument is no, 452 is my separate standalone procedure. But I don't see in that any authority to take public comment there either. And so if we're going to read these statutes in such a way as to be very clear about what must and must not be done, what do we do with actions taken under 16452 that aren't required or aren't provided for that we find within the APA?
And I mean, we may just simply have a disagreement. I don't think 16452 prohibits the Secretary from going further and consulting with other stakeholders, right? So 16452 says you have to consult with the counties. There are other local jurisdictions that hold elections. Does that prohibit the Secretary from consulting with cities that hold elections or school boards? Of course not. These are reasonable things you could do in the exercise of good government. I don't think they're prohibited by 16452.
Why couldn't those individuals, though, consult with the county officials? And the reason why I'm asking this is that when we get done with figuring out whether it's 16452 that applies or the APA, everybody's on notice now going forward what can and cannot be done. And if the APA doesn't apply, we say it's 452 and this is what it requires, well, now you may have other legal challenges with a 2025 EPM.
Yeah, I guess, Your Honor, we might just have to agree to disagree. I don't think that issue has been raised, and I think it would be within the Secretary's implied.
Was there any customer practice in terms of soliciting comment from the public with respect to the Secretary of State's office?
So as the amicus brief from Secretary Bennett noted, he initiated the practice of requesting public comment because he thought it was the right thing to do in terms of good government. So that has been done for a period of years.
May I ask a question about in the respondent's brief? I believe it was the respondent's briefing, or it could have been an amicus brief. There were some constitutional arguments made about Article 2, Section 2, that all political power is inherent in the people, and governments derive their just powers from the consent of the governed, and the provision that provides that the people constitute the lawmaking power. And so I have a question just briefly about how do you respond to those arguments? In this case, the people, the argument is that the people, I understand it's been the practice to provide the public the notice, the comment period, but if there is no requirement under law, how it seems to cut off the ability of the people to provide comment in with respect to the EPM. And so how do you respond to those? How do the Constitution frames this or doesn't frame it?
Yeah, my understanding, you can ask opposing counsel, is that the respondents haven't made a constitutional argument, and it's just amici. Of course, amici can't expand the issues before the court. I would say also the APA isn't constitutionally required, right? I mean, we had a state before there was an APA, and so it's not constitutionally required. And so I don't think that those provisions change the statutory analysis here. I would, if I may, before I reserve some time, like to talk about some of the practical concerns that I think would flow from the respondent's interpretation, and there are 5 of them in particular that I want to highlight.
Counsel, there is one that I would like you to start with, if you would, and that is, you mentioned in your brief that there's an impact on rural counties due to their limited access to specialized election staff and there are fewer resources. Can you talk about what the impact would be to rural counties and then the practical effect of applying the APA retroactively starting with 2019?
So the legislature has stated in 16452A that the purpose of the EPM is to ensure the uniform and correct administration of election law. I'm paraphrasing. I think that's especially important for smaller counties, which in our state are often rural counties that have smaller staffs in their county recorder's office or the county attorney's offices, therefore less specialized staff, and therefore benefit more from the considered advice and rules in the EPM than the larger counties that may have more ability to do specialized legal analysis on their own. And so reverting to the 2019 EPM, as respondents have suggested, would be especially problematic for those smaller counties. And that's especially true in light of significant changes to election law that have been promulgated by the legislature between 2019 and 2023, including with respect to rules regarding documentary proof of citizenship and documentary proof of residency, which are very complicated both on their own and in light of pending federal litigation. The 2023 EPM spends considerable pages trying to help counties understand how those interact with existing law and how to think about federal law as well. The 2019 EPM just doesn't mention those at all because they weren't in statute at the time. And so I think that would undermine the statutory purpose of the EPM under 16452A. The other impact on the counties more broadly is that under respondents' interpretation, counties would simply have less influence on the EPM process because the Secretary of State would have to spend more time with the public comment process and going back out for public comment if any substantial changes were made as a result of public comment. That would shorten the period with the counties, and it would also mean that the counties would be able to have less input to the secretary regarding what to do about the public comment. So the secretary spends a tremendous amount of time consulting with the counties throughout the year, chapter by chapter, oral feedback, written feedback, talking to them about the public comment, really trying to do a document that's helpful to them. And that would be harder under the respondent's
But
interpretation.
is it possible to comply, as the RNC says, to comply with both the EPM statutes and the APA? If there's no direct conflict and it's possible, is that in itself something that evidences another law says otherwise?
So I don't think impossibility in all instances in the test. I think the test is whether there's a distinct set of procedures set out by one statute or another. And it might be possible in some years and not in others, right? So let's say the public comment period identifies important changes that the secretary ought to make to the EPM. And those are substantial changes within the meaning of the APA. The secretary would then have to do a supplemental notice, go out for another 30 days, which could trigger a 30 days after that for an oral proceeding. And that could make it simply impossible to promulgate the EPM within the statutory deadlines in 16452. Even more so if the Attorney General and the Governor said, well, I disagree with you, and I think there's an important change you need to make. And that change was also a substantial change under the APA, and the Secretary then had to go out again. So there are lots of conflicting approaches, and what that also could mean is that the role of the Attorney General and the Governor are diminished because they might be limited in many years to either saying, yes, I approve this, or no, I don't approve this, and not being able to say, I think important changes need to be made because there simply wouldn't be time for that. It would also make it harder to just make any changes as a result of public comment. And it would for other reasons, it would shift major authority over elections to the Governor's Regulatory Review Council. We mentioned this a little bit, but it's a huge lurking issue under ARS 411033. GERC can waive or modify rules without any judicial review whatsoever. And under their interpretation, if the APA applied to the EPM, GERC would now have tremendous authority over election law and administration in Arizona. There's no indication that the legislature
I know you want to
intended
sit down,
this.
but last quick question, because I really want to know that if your position is correct, would the secretary still have to comply with Section 1012, which says that for all exempt statutes under the APA, you still have to publish in the Arizona Administrative Code and have other public notice?
I think it depends on whether the court would side for us under 41-1002A, holding that it's exempt under that provision, or under the other avenues I've identified, and that would define whether the exempt rulemaking provision is triggered. With that, I'll reserve the 2 minutes plus I have remaining. Thank you.
Okay, Mr. Murray.
Thank you, Madam Chief Justice, Justices. Chris Murray on behalf of respondents. With me is Julian Ellis and Kurt Altman. May it please the court. We've heard a little bit about the impact that this case may or may not have on election law administration in Arizona. I would put it to this court that this case is primarily a case about the Administrative Procedures Act and what the Administrative Procedures Act requires when the legislature delegates rulemaking authority that is a portion, right, of its lawmaking authority to the executive, to a portion of the executive function of government. And
Seemed that way in practice. The legislature has sometimes amended both statutes in the very same year without doing anything to intersect those laws. But even more than that, as your opponent has stated, as Mr. Benner has stated, the EPM identifies its goal, which is the efficient administration of elections. It's set specific dates that are different, far different from whatever APA procedure would apply. And they seem very logical. October, for example, it's after the legislative session, before the election season begins. Aren't these really two ships sailing separately in the night?
or I don't think I've heard it quite that way. Maybe ships passing in the night, Justice Bullock. But yeah, right. That's true. Yes, we don't want them to be ships sinking
Don't get
in
too
the night.
specific on the naval reference.
I would say, respectfully, Justice Bullock, to the extent they have been, or to the extent they've been treated that way, they're not. And the Administrative Procedures Act, where there is, if there's a question, right, the Administrative Procedures Act, by its own terms, has to trump. Here, though, and I thought it was, I really appreciated the candor of Mr. Bender in his argument when I believe Justice Montgomery, you asked him, well, what's with the public comment thing? And Justice Lopez, you asked about whether or not there was a practice of doing that. Geez, 452 doesn't talk about public comment. If the whole thing is efficiency in the administration of election laws, why do that? And you even said, did that thing set this whole thing off? Well, I would say that Mr. Bender in response said that nothing in 16452 prevents the secretary from doing more, from deciding to do more, from going beyond 16452. I would say that the APA requires him to do more because he can comply with both. And I would point this court back to Section 41-1002B, which says exactly what happens, right, when there is a conflict between the APA and another statute. It says that the rights created in the APA are procedural. They're in addition to those provided by any other statute. And, quote, to the extent that any other statute would diminish a right created or duty imposed by this chapter, the other statute is superseded by this chapter unless the other statute expressly provides otherwise. 16452 says a number of things. It nowhere provides an express exemption in the formulation that exists in the APA or in the various enabling legislation that we've cited in our briefing. Chief Justice.
Thank you. What about?
I saw the green light.
I
so,
know.
yeah,
I've never
it's
been
actually
called
really
on
helpful.
before.
Yeah.
What about? You know what I'm going to ask? I asked the same thing of Mr. Bender. What about 16444B? I know that is an oddly worded statute, but it says the provisions of all state laws relating to elections not inconsistent with this article apply to the elections where electronic tabulating devices are used, and any provision of law that conflicts with this article, which includes 452, does not apply to the elections in which electronic tabulating devices are used. So why isn't that the other law that you just referenced?
And for the record, when this argument was raised for the first time before this court, I found it clever. But I will just say that it doesn't work simply because you have a long road to get there, and at the end of the road, 1002B still wins, and I'll say why. I try not to have too long of an answer. But the long road to get there is, first, there is no conflict between 16452 and the APA. There is inconvenience, I will admit that. Secretaries that are used to not taking public comment, secretaries that are used to not giving the basic procedural protections that are in place for any other rule of general applicability in the state, of course they're going to prefer to not have that. And there are the deadlines that Justice Bollock pointed out, that you've got to get it to the governor and the attorney general by October 1st, and it's got to be out by the end of the odd-numbered year.
Well, let me stop you there because I know you're going to go on with the rest of the explanation. But since we talked a lot about conflict before, and what is a conflict? It's either one of two things: an impossibility to adhere to both statutes,
Right.
or simply that one statute has a pretty comprehensive, self-contained vision of how these rules need to be employed, and the other has something that's different. Isn't that so? Is that a conflict? So how do you define the conflict, and what is your best authority for your position?
Well, so let's say, in fact, let me just, maybe it's better if I explain what happens at the end of the road if you find a conflict, for the sake of argument, right? If, for example, this court decides, a conflict it's enough where there seems like there's another statute that is speaking to this, and there's some meat on the bone there. There's some process, and geez, doesn't that supplant the APA? We find a conflict. I would note, by the way, that would call into question a case from the 1997 out of the Arizona Court of Appeals, and this is City of Phoenix versus 3613 Limited, and that related to procedures before the Liquor Control Board. There was an independent statute that provided for how those procedures worked, and the Court of Appeals there held that in view of 1002B, it's no longer valid to conclude that because the Liquor Control Statute contained provisions regarding hearing procedures for those hearings, the provisions of the APA don't apply. However, let's say there is a conflict. You find that the two are in conflict with each other. Well, then I think we argue 1002B wins. Why? Well, because 16444B, right, what the basic canon of statutory construction is later in time. Mr. Bender quoted that canon of construction to you, and that's under Webb versus Dixon. 16444B was added in 1979. To the election code. 41-1002B was added in 1986. And so if they are truly irreconcilable with each other, then the later in time canon provides that 1002B prevails over 16444B.
Why can't 1002, even being later in time, simply be, all right, there is something other or exempted, and that's the then existing 444B?
Well, I mean, because of the language in 1002B. I mean, I think that's really tough language to get around. The language in 1002B says that, I mean, there's got to be an express exemption that this grants rights in addition to. I think that's the language I would urge you, Chief Justice, to think about. Right?
Counsel, you mentioned express exemption, and I want to highlight that within 10,002B, it doesn't provide for exemption. I mean, that second sentence, the last clause, unless the other statute expressly provides otherwise.
Right.
And why can't that be an exception versus an exemption? In which case, you could read the language in 1030A, which I'm sure you're going to get to, that references otherwise provided by law. I mean, the language is different, and as the parties have briefed, we should give that different language different meaning.
Well, I might have to agree to disagree with you there, Justice Montgomery.
You join your opposing counsel.
I think expressly provides otherwise, and I can get to 1030A in just a moment, right? But expressly provides otherwise, that's in the context of Section 1002, right? Which 1002A says that this chapter applies to all agencies and all proceedings not expressly exempted. And the express exemption formulation heretofore under the APA has been obvious, right? It's either this rulemaking, these proceedings, these set of rules are exempt from Title 41, Chapter 6 of the Arizona Revised Statutes. That's the form that those exemptions take. And I think expressly provides otherwise means it's saying expressly that no, you don't get to add the APA onto this statute because we're saying it doesn't get added. This is a sui generis provision. 1002B, I think it's that in addition to language, that they are in addition to rights granted by other statutes. That's important. Justice Cruz, I see the green light.
Go ahead. You can finish.
No, that's okay.
Okay. So let me just a second. So would we decide that the GERC holds the authority to review and modify, revise, or declare void any rule of the APM? Or would we, under your position, still allow for an expedited judicial review process?
Frankly, I think that's I mean, that is up to this court. I'm not sure that this case squarely presents that issue to the court for decision.
And well, I'm just trying to understand how the two would work together because of these fundamental differences. And then there's the issue also of governor approval. Would we, under your vision, still find that governor approval is necessary as the EPM requires?
Yes, so I think I follow your question, Justice Cruz. So our position is and has been that the Secretary can and must comply with both 16452 and the Administrative Procedures Act. And so, yes, we're not trying to strip the other portions of 16452 out of the Act.
So, counsel, if that's true, then you can't be before us today in any future challenge to the EPM unless you've exhausted all your administrative remedies.
That is potentially correct, Your Honor. That's potentially correct. However, I will say that, remember, there are grounds. The APA provides grounds for challenging a rulemaking, and one of them can be that it's not necessary, right, or it's not unauthorized, it's not delegated, it's beyond the delegated powers of the agency. So I think those two, the tests that you've already had in Girk, right, they overlap pretty nicely there. I think functionally, the question that you'll be forced to decide in future challenges to the substance of an EPM enactment will look a lot like what you've done in the past.
And then let me throw this out there so you can deal with it when you get to 1030A. But I'm wondering if with the different provisions you've cited so far dealing with exemptions, if this framework that we have within the APA doesn't provide for 3 instances in which an agency doesn't have to follow the APA. One is if the agency itself is expressly exempted.
Mhm.
The particular area of rulemaking is expressly
Expressly
exempted. Or, under 1030A, the legislature has otherwise provided by law exactly how the legislature wants an agency to promulgate rules.
So, and where I would disagree with you, Justice Montgomery, I'll get to 1030A now, is that last or. We think the Court of Appeals got this exactly right with what 1030A is, and I would urge the court to spend some time, as Mr. Bender initially urged you to and then kind of backed away from in his response to Amici, spend some time with the legislative history of this additional piece in 1992 to Section 1030A, because how did that come about? That came about in House Bill 2578.
Before you get to that, counsel, you characterized, you argued in the Court of Appeals that 1030AA was remedial. What does that mean? It was remedial. I think Mr. Bender brought that up in his papers. Explain to me what you meant by remedial.
All we mean is that it clarifies what the proper remedy is.
Isn't that the same as superfluous?
No, actually, we don't think it's superfluous. We think it's clarifying, and we think this is Justice Bean. What I'm getting to is I can only take what the legislature said they were doing when they did it, right? And there was a House Bill 2578 proposed a whole set of reforms. In fact, Chief Justice Timmer, one of your questions to Mr. Bender at the end of his argument got at some of these changes, which is, hey, even if we find for you that it's exempt, will you still publish it in the register as required by some of the changes to the APA? Well, that was House Bill 2578. And in that legislative process, Senator Furman, I don't pretend to have known him, but Senator Furman offered an amendment saying, hey, whoa. If we're going to start bringing exempt rulemakings and require that expressly exempt rulemakings show up in the register and do some other APA-like things, shouldn't we clarify that in this provision, which the 1030 provision had always been there, right? If you don't, any rule is invalid if you don't follow it, right? They just added the unless otherwise provided by law. Shouldn't we add this to show that now we're talking about some express rulemakings in the APA and expressly exempt rulemakings in the APA? And shouldn't we note that those exist? That, hey, if you've got an exempt rulemaking, of course it's not invalid for not following the APA.
Then wouldn't it have been clear had they said unless otherwise provided by 41-1002A or B?
I would concede that point. But nobody elected me to the Arizona State Senate. Yeah.
Well, that brings us back to what express exemption means, because we certainly have the language and we want to give, obviously, meaning to that language of what is meant by that. And in the past, we've never really required any kind of magic words to show an express exemption or something different procedure. And we've said in cases, the City of Phoenix versus Glen Air Electronics, by using the phrase notwithstanding other laws, a particular law the legislature, quote, as expressly and definitively declared that in that case, a statute of repose controls over another general exemption that existed. And in State versus Jones, noting the legislatures often use language such as notwithstanding other statute to indicate a particular provision will trump any conflicting statutes. So I keep circling back to 444B of why that isn't evidence in and of itself of the legislative intent that that's going to be freestanding and will not be controlled, as it's one of those other, unless otherwise provided by law, frankly, under 1002B.
Well, yeah, I mean, and Chief Justice, I would simply say, number one, again, remember which one came later. It was 1002B. And I would also point out that, and we mentioned this some in our briefing, if 1030A is actually a brand new exemption, that actually, so the APA has talked about express exemptions, has to be express all the time, but 1030A in 1992 worked a revolution in Arizona's APA and actually created what is an implied exemption, right? That, hey, the existence of another body of law that provides for the rulemaking actually impliedly gets you out from under it. 1002B effectively doesn't do any work anymore. It's language about that the rights there are in addition to those granted by other statutes, and unless the other statute expressly provides otherwise, it's superseded. 1002B was then amended out of existence, kind of without anybody noticing it in 1992. And I would say, going to one of Mr. Bender's themes, right, that we'd have that here, if the EPM is subject to the APA, that's a surprise to election law practitioners. Well, I would tell you that if 1030A does that, I'll bet you that's a surprise to practitioners under the Administrative Procedures Act. And the incentive for agencies is going to be to start looking to see, hey, is there anything about our rulemaking outside of the APA? Do we have maybe an argument for a 1030A express exemption? And I think the path to more litigation under the APA is there. And Justice Montgomery, I see the green light.
So let's see if you disagree with me on this. And I know we've talked about, the more recent enactment with control over preceding enactment. When I look at these two different statutory schemes, the EPM initially enacted in 1972, which included the 16-452 provisions. And then in 1986, we get the APA. But since then, from 1993 to 2019, we've had 4 different amendments to the EPM. And since 1986, one which you've referenced, we've had 8 different amendments to the APA framework. And yet in between these, if we bounce back and forth, try to figure out which one's most recent, I'm not sure where we end up. And what I'm wondering, and why I'm mentioning this, again, you may disagree, but I wonder, doesn't this series of amendments, without, as Justice Bullock identified, any cross-reference at any period of time, support better a view of this, that the legislature was dealing with the EPM as a sui generis set of directives to the Secretary of State, exercising that control, versus requiring it to comply with the APA, when they've had all 14 opportunities to do that?
Well, I mean, and I would say at bottom, Justice Montgomery, where that's coming from, it's an argument from legislative acquiescence, which I don't believe this court has ever given much credence to. That, I mean, legislatures have to do lots of things, and just because they're dealing with the statute, I think, and I would urge the court to reflect on the history of the EPM, how the EPM came to be what it is now. Like, why are we here now? The EPM does a whole lot more now than it ever did. And the EPM, by doing a whole lot more, affects the rights of far more people than it ever did before, and it affects far more questions around election law. And so I would say that sort of that development actually points to, right, like, well, why does the APA need to apply to this, right? Because of it's essentially a 260-page manual of laws of general applicability. I would like to say one thing about
But counsel,
perspectives.
going to that point, it sounds like you're going to some sort of public accountability argument, but isn't there accountability in the fact that the Secretary of State and the Attorney General and the Governor are elected officials, and they can simply be ousted at the following election?
Well, there's some accountability there, but I would point the court to another piece of this process. Mr. Bender mentioned, like, oh, hey, it'll be it'll be tough for counties to get their time at the table if the secretary has to deal with the public. I would urge the court to take a look at Pinal County's amicus brief in this case, which I think puts a little bit of the lie to that. Pinal County got a provision inserted against its wishes after the public comment period by the Attorney General and the Governor. Nobody in the public saw it until it was issued. I see that my time has expired. We would urge the court to affirm the Court of Appeals.
Thank you, Mr. Murray. Mr. Bender.
The respondent's arguments in this case pose significant risks of harm and confusion to the administration of elections in Arizona. This is not principally an issue that for the secretary, but for the county election officials and other local election officials who have to do that work and for whom the EPM is an important help. And I don't think the respondents' arguments grapple with the risks that their arguments pose. I think you heard that with respect.
But are we to grapple with the risks? I mean, this is policy. If the legislature wants to have APA and the EPM, that's really not for us to say that that's a poor idea, is it?
Well, when the court is looking at legislative purpose, as stated in 16452A, the purpose of the EPM is uniform and correct administration of election law, which everyone agrees is a good thing, then yes, the court is to look to that. And that's also true with respect to prospective-only application, which this court has said is a policy decision within its discretion. And I think you see that also in their suggestion, well, it'll be just fine, just use the 2019 EPM. That wasn't even promulgated under the APA, and it could be challenged for invalidation under the APA in situations in which the statute of limitations issue wouldn't even come into play. And I think their resort to ambiguous legislative history is telling. As you heard, every interpretation they try to give to you of 411030A necessarily adds words to the unless otherwise provided to law clause that simply aren't in that clause, and that's not what this court is supposed to do. Ultimately, the problem posed by a respondent's argument isn't so much about public comment. As the court has recognized, that's something secretaries have done and are able to do. And if so, the court says that, well, that can be required without creating a conflict, the secretary can live with that. The real practical problem is that the secretary, under respondent's arguments, would have to go out for a new round of public comment anytime he made substantial changes after the initial public comment. And that poses all of these problems that we've talked about today. Lastly, in terms of statutory history and the legislature not taking action or reenacting a statute, there is case law from this court saying that matters. I'd cite the court to the Jenny versus Arizona Expo case, which we cited in our briefs. Thank the court, and I hope you'll affirm the dismissal of the APA claim.
Okay, I thank all counsel for your, not only for your briefing, but for your argument today. It was very illuminative, very well done, as expected. We will take the matter under advisement and issue an opinion in due course. Before we adjourn, because I know that the class is going to change, and so I wanted to take the opportunity to thank counsel, first of all, for coming down. We deeply appreciate it. I think it's of value for students to be able to witness this, and particularly your caliber of advocacy is an excellent one for them to aspire to. So we thank you for coming down for that. Also, I'd like to thank the people from the court publicly that make this possible. Not only do we have folks on the communication team, the security team, the IT, who else am I leaving out? People that got us here, and all of the law clerks that came down. Law clerks, can you kind of all wave? Yeah. Oh, they always sit together. I don't know why. They must like each other. But I know for this group, it's a shame you're not going to be here for some of the question and answer for us to introduce you a bit more. Raise your hand if you're from U of A. It's a lot of U of A people this year. Yeah. So, yeah. So I think I've hit everybody that I'm supposed to thank, right? Yes. So with that, we are going to not adjourn, but recess to give folks an opportunity to switch out, and we'll be back for the second case.